go from there.
This meeting is being recorded.
Good evening, everyone. Welcome. Today is January 24th, Monday evening at 7 o'clock. I want to welcome you to the Town of Cohasset Conservation Commission meeting. The meeting this evening is going to be a kind of a Conservation Commission pre-treatment. Can't get that out of my head in my day-to-day life. 101 form of presentation. But prior to doing that, just want to go through a roll call vote. When I say your name, just say whether you're here or not present. So I see that our chair is slowly joining in. My name is Jay Pimpari. I'm the vice chair. And until Chris formally joins us here, I'll continue to chair this meeting and turn it over to him. But Jay Pimpari, present. Tom?
Tom Bell, present.
Eric?
Eric Eisenhower, here.
Kathy?
Kathy Berrigan, present.
Chris, can you hear us?
Chris McFarland here.
Excellent. And so we have 1, 2, 3, 4, 5 commissioners present, and Chris McIntyre.
Chris McIntyre, present.
Thank you, Chris. Chris McIntyre is our associate member. So we have 5 members in attendance this evening. That does constitute a quorum. I will now, Chris, your video's not on, but if you, I'll let you chair the rest of the meeting here. I'll turn it back over to you in a minute, or let me just turn it over to, yes.
Jay, can I ask you to keep going, please? I'm on the road and it's
Oh yeah,
trying to find someplace I need to go. So
no problem at all. It's all good. So Charlotte Petchel is also our Conservation Commission agent, and Charlotte, I'm going to just briefly turn it over to you, and I should also acknowledge our legal counsel, Amy Quessel. And so before I do that, again, I just want to remind everybody that this, and Amy, please fill in the gaps of anything that I leave out here. This is a public meeting. Members of the public can listen in if they choose to do so. So don't get a little long-winded here to commissioners and think that this is a meeting that's just amongst us. The public can view this tape later on. It'll be on YouTube. We will not be deliberating on any particular project. Amy, I don't know how you feel about giving examples of projects that have already been closed out, order of conditions issued, if we talk about a particular situation from 3 or 5 years ago, if it even comes up. But again, I want to let everybody know this is not for deliberation on any particular project, and the public may jump in here at any point in time. So without further ado, I want to turn it over to Charlotte. I know we talked about this for quite some time and having the training. I don't want to chew up any more time of our valuable evening before we turn it over to Amy to get going. But Charlotte, if you had anything to say before we kick it over to Amy.
Sure. Hi, everyone, and thanks for calling in. We appreciate your time. I would like to introduce Amy Quessel. She is our Town of Cohasset's legal counsel for the Conservation Commission from K&P Law. We set this training up, since we have some new commissioners. I felt it would be helpful to set up a 101 training, if you will, about the basics of conservation commissions and the Wetlands Protection Act and the Cohasset bylaws, and just go from there with various topics. And with that, I'll turn it over to Amy, and let me know if you'd like me to share my screen, Amy, or if you want to pull up yours.
Sure. If you want to share yours, that would be great. So thank you, everyone. So again, my name is Amy Quessel. I am with KP Law. Just so you guys know, I started serving on a conservation commission, I think in 1996 or 5. And I served on the Situate Conservation Commission for, I think, about 10 years. And then I served on the Marshfield Conservation Commission for about 13 years. And I focus my practice on conservation matters and other land use matters also. So I would love to echo what the vice chair had mentioned with regard to tonight. We will not be referencing any projects. We will not be referencing any addresses. This is a general overview. So any questions would be, any questions that have scenarios would be hypothetical. So, so anyway, we can move on. These are just introductory slides. I think the first three, Charlotte, are introductory. The next one, okay, here we go. So this is what the presentation tonight is going to be about. We have general laws that apply to all municipalities. These are statutes, they're state statutes. We have the Wetland Protection Act, we have the open meeting law, the conflict of interest law, and the public records law. So we're going to touch on all of those tonight. We are also going to touch on your wetland bylaw, your local town of Cohasset wetland bylaw, and your regulations that stem from the local bylaw. Chapter 40, section 8C, that is the statute that creates conservation commissions, and it sets forth your powers and duties under the statute. As a conservation commission, I know it feels like all you do is review NOIs, but you actually have the power to plan, acquire, manage open space, encourage and monitor conservation and agricultural preservation restrictions. You can also accept gifts of money or land without the need for town meeting approval. You do need approval from the select board, but you do not need approval from town meeting. We can go to the next slide. So under the, sure.
Would you entertain questions as we go along, or?
Sure, whatever's easiest.
Could you go back a slide, please? My name's Eric, by the way.
Yes.
No, that's the wrong way. Okay. One thing which we should bring up is this question of the second issue: plan, acquire, manage open space. We don't do that. I know it's in our strategy statement. It's in the strategy statement of most, and mission statements of most Concoms and the South Shore, because we've looked through them when we're doing mission statements and strategy statements, and they all have they have visions of acquiring open space for animal welfare purposes and all this, but we don't do that at all. In my 4 years, I don't think we've acquired or been involved in any land space or open space activity. We have an open space committee, which is separate from the Concom. In a lot of towns, the open space committee is a subdivision of the Concom, but not here. So when we talk about this question of managing the future land and growth of Cohasset's open space, we're not really involved in that at all. Period.
So, so first of all, an open space committee can recommend property to be obtained at town meeting, but it's for conservation purposes. An open space committee by statute cannot own land. The Conservation Commission can own land in their own name at the Registry of Deeds. So there are very few groups in town that can own property. It is the Select Board, the Conservation Commission, and the Department of Public Works for water protection resource. Usually that's why the DPW will own property, is to protect any wells or things like, or surface water, things like that. So, you know, even though the Open Space Committee, which I've served on an Open Space Committee, and I think that the Open Space Committee is a great vehicle to take some work off of your hands. They need to be going out there. They need to be following an open space plan and bringing properties to town meeting to be acquired by the Conservation Commission, or you know, gifted to the Conservation Commission. The other thing is that some municipalities will have so for example, they'll have a cluster subdivision in their zoning bylaws where a developer can have reduced lot sizes for a subdivision, and they have to set aside a parcel for open space. That parcel for open space has to be owned by either the Conservation Commission, it has to be owned by another nonprofit that's a land management nonprofit such as Audubon, and almost always there has to be a conservation restriction placed on it, and that conservation restriction would be regulated and enforced by the Conservation Commission.
I will move on to another subject. We can come back to this later. I don't want to hoodwink.
Okay.
Okay, but we can come back later on. Excuse me. All right.
So the next slide, Charlotte, if you don't mind. So the Wetland Protection Act and the bylaw, these are the tools that we use to protect the wetlands. So the laws and the regulations, whether they be the state or the local, what they do is they describe the resources that are protected and the specific protections, that are provided, under the act and its regulations. No person shall remove, fill, dredge, or alter, any area subject to protection without the required authorization. And the next slide. And then under your bylaw, you guys have no person shall remove, fill, dredge, build upon, or alter the following within the following resource area. So you guys have within your for your listed resource areas, you have within 100 feet of any freshwater wetland, marsh, wet meadow, bog, or swamp, 100 feet of any bank, lake, river, pond, stream, or estuary, any land under a lake, river, pond, stream, or estuary, 100 feet of land subject to flooding or inundation by groundwater, surface water, or tidal action. And then you have within 25 feet of any isolated land subject to flooding or any isolated vegetated wetland. And then you have within back to 100 feet of a vernal pool. This is a little bit unusual where you actually reduce it down to 25 feet when it comes to isolated land subject to flooding or an isolated vegetated wetland. The other interesting part here is that, as I'm sure you all know, under the Wetland Protection Act, the Rivers Protection Act was incorporated into the Wetland Protection Act in 1996, and the state statute provides that there's protection 200 feet from any river or perennial stream, and you guys don't have that. You are within 100 feet. The next slide. And then, so these are the wetlands that are protected under the statute, under the state statute. And they're a little bit more general, I would say. So it's freshwater wetlands, land subject to flooding, riverfront areas, banks, land underwater, land subject to coastal storm flowage, coastal wetlands, beaches, dunes, land subject to tidal action. And then the Wetland Protection Act, they have the interests of the act, and these are the reasons why we protect the wetlands. And they are public water, private water, groundwater supplies, flood control, storm damage prevention, prevention of pollution, protection of land containing shellfish, wildlife habitat, and fisheries. And then the Cohasset, under your wetland bylaw, you have all of the same, except you have, under your bylaw only, you've added recreation, aesthetics, and agriculture. That is very common that a local bylaw will add those three. So we can move on to the next slide. So, so with the Wetland Protection Act and how it relates to resource areas, it's any action that will alter a resource area. It's presumed to have an impact on one or more of the interests of the act. Whether it be storm prevention or groundwater supplies, things like that. And the act requires that the Conservation Commission use the permitting process to impose such conditions that will contribute to the protection of the interests. So the law presumes that the work in a wetland, in a resource area, will have an impact. The Conservation Commission doesn't have to prove that the work within the wetland will have an impact. The burden of proof is on the applicant. And the biggest difference between the Wetland Protection Act and the Wetland Protection Bylaw is the act really only protects work within an actual resource area, whereas the bylaw protects from 100 feet and in certain circumstances only 25 feet out. It protects the buffer zone also. So we can go to the next slide. So under your local wetland bylaw, it's any activity which will constitute removing, filling, dredging, or altering any resource area And again, any activity proposed or undertaken with land within 100 feet or that one instance of 25 feet. And any activity that's proposed or undertaken outside of the buffer zone or resource area are not subject to regulations unless, in the judgment of the Conservation Commission, said activity has resulted upon the removing, filling, dredging, building upon, or altering a resource area. So that's a little bit, that's a little confusing because, you know, the commission is going to have to show that whatever's being done 150 feet away is somehow removing, filling, dredging, building upon, or altering something, you know, the land within 100 feet from a resource area. So I think really the biggest thing there would be probably sedimentation and erosion would probably be the two things that would happen there. So the next slide.
So
is,
Amy, sorry, just a quick question on that. So
Sure.
I know we're focusing in on the Mass DEP and Cohasset wetlands rules and regulations, not the stormwater. So obviously activities outside of 100 feet could trigger if they're greater than 500 square feet of impervious, or clearing or altering of more than 5,000 square feet. In that case, obviously would require a permit. But we come across the situation many times where someone's at 110 feet and they want to take down 5 of these giant, beautiful oak trees. And it's like, if it doesn't trigger a stormwater permit, the commission's hands are pretty much tied outside of 100 feet. Would you agree with that?
correct. I do agree. Yep.
Okay.
Yep. So, so the local activities that are subject to, you know, regulation pursuant to your bylaw, you know, it's any, oh, go ahead. Yep.
We see that those trees that Jay is talking about, the presumption is they can't take them down unless they change the hydrology or the drainage of water through the 100-foot area. Because you take down these big trees, you're certainly going to disrupt what's going on under the ground and the water flowing down into the buffer zone. Nope.
Nope. It has to be dredge, fill, or alter. You can't, there can be no, you know, presumption. It has to be, there has to be evidence that it's, you know, dredge, filling, altering. So, you know, it's tough. It's tough when you have something outside of 100 feet. And, you know, if it's subject to a stormwater permit, then it has to be 500, you know, 500 square feet. But if it doesn't total that, then it's very difficult to show that that's going to impact.
What about spraying of rampant quantities of herbicide 101 feet outside of the 100-foot area that then flows into the buffer zone? Nope.
Nope. You'd have to show that the surface water is, you know, bringing it in, and you'd have to show that that is removing, filling, dredging, or altering.
All right.
Yeah. So it's tough. We can go to the next slide. So the applicant has the burden of proving by the preponderance of the credible evidence that the work proposed will not have an unacceptable, significant, or cumulative effect upon the wetland values protected by the bylaw. That's a very common burden of proof. The difference really being that it's can either be a significant or a cumulative effect. So, you know, if somebody is just going to, you know, dredge one area, you know, does that necessarily mean that it's unacceptable? But if there's the cumulative effect between that and all the rest of the work, then maybe it could be unacceptable. So that's where we're at with that. And the next one.
So Amy, just to kind of flesh that out a little bit, would we then weigh that against maybe the number of interests that would be impacted? I mean, let's
You
say
always, yep.
you do something and only one interest is at stake. But if it's a cumulative thing, at least in terms of the interests. So if we see something that we think is going to impact 2 or 3 or more interests, it seems to me then we should be more stringent within our 100-foot buffers than perhaps we are. You know, we basically don't let anybody do anything within the 50, but we're relatively permissive within the 100 or more permissive.
So,
And so should we perhaps be judging how much people should be able to do between 50 and 100 feet out, and should that depend on the number of interests that are impacted?
it should. You should always connect any kind of activity with the interests of the act, always. So I'm really happy to hear you say that. So that should always be in your mind, is what interest of the act is this activity impacting? I mean, there could be an activity where it doesn't impact any of the activities, between 50 and 100, and it should be allowed. So, and then the other thing too is that your conditions should be geared towards how to protect the interests of the act. So, when you have work within 100 feet, how can we condition this to, to show that it will not impact, any of the wetland values. And, the one that always stands out with me is, erosion control, conditioning it so there are proper erosion controls, and those erosion controls are, removed when the project is over, and we don't have, hay bales out there for forever that turn moldy and gross. So, those are the things that we want to look to. So we have exemptions. There's exemptions within the Wetland Protection Act, within the regulations, and then you also have specific exemptions within your bylaw. So you have an exemption, which is the first one under A, is it mimics the Wetland Protection Act, and that is utilities, and that's any kind of work that pertains to utilities, electric, gas, water, telephone, telegraph, or other telecommunication services. And then there are, there's conditions there, which is it makes sure that it's not that the facility is not substantially changed or enlarged. It's just maintenance work. Written notice has been given, and the work, conforms to performance standards and design specifications, in any regulations adopted by the commission. So this is NSTAR or Eversource or whatever the power companies are nowadays. But, they are, it's classic for them to just go in and start, cutting down vegetation as part of their maintenance for their high power, their high tension lines or something like that. And I fight with them all the time, because I get it. You're not enlarging or substantially altering your, your utility line, but they never give the commission, written notice, and they never look to see if there's any kind of regulations or anything like that. So it's a constant battle, I will say. The permit does not apply. Also, the permit does not apply to emergency projects that are necessary for the protection of the health and safety of the public. And again, this is a little bit, this also mimics the state act somewhat, where the work is, so if the work is going to be performed by an agency of the Commonwealth or a political subdivision thereof, so that would include work by the town. The town is a political subdivision of the Commonwealth. And there's been advance notice has been given to the commission or the agent within 24 hours. And the commission or the agent has to certify work as an emergency project. And the work is performed only for the time and place certified for the limited purposes necessary to abate the emergency. So if you have say, for example, a seawall collapse that is going to undermine a house or a building, in that emergency, you want to allow them to do the work that they have to do to shore up that wall. You're not going to allow them to put in a whole new wall. It's just to abate the emergency is what it's supposed to be. And then again, within 21 days of the emergency project, they have to file with the commission an after the fact notice of intent. The act provides for 30 days, but your bylaw only allows for 21 days. And then your bylaw also allows for any exemptions or emergencies that are listed under the act, which really there's not, because your bylaw kind of mimics the act. So
is that what C means? I was reading that today, and I wondered if, in fact, it meant that that we trump MGL when it comes to these exemptions.
So you
We can
do,
be more
however,
we can be more restrictive, in other words.
you can, however, under the Wetland Protection Act, there's really only A and B. So the Wetland Protection Act doesn't necessarily allow more exemptions or emergencies.
What about things like, what is it, limited project status? Does that fit into this rubric?
Well, no, because a limited project is not exempt. A limited project is not exempt. It still has to go before you. It goes before you as a limited project. It's just a different review standard, but they're not automatically exempt. You are allowed to, under the Wetland Protection Act, you're allowed to allow a driveway to access upland of a property if there's no other way to get to that property. That doesn't mean they don't have to file. Exemptions mean they don't have to file. An emergency means they can do the work and then file later.
So in other words, if, let's say, somebody wanted to put in a driveway across the wetland because that's the only way into the property, do we have to let them do it?
What we end up with is we end up with the Wetland Protection Act saying that they can do it, provided that they prove that there's no other way to get in and that there was never any other way to get in. So meaning you can't subdivide your property to create this upland and then have to go across. And then the other issue is that your bylaw provides for, or your regulations provide for a variance provision to avoid a regulatory taking.
What does that mean?
So you have to evaluate it to make sure that you're not completely depriving the property of all of its use.
I
want to just jump in here because this, sorry, Tom, I just, before I lose this train of thought, the situation may or may not have occurred in the past, whereby I'll give you a hypothetical situation. You have a full, let's say it's a 2-acre lot, and the only way to access the property would be off of Main Street, because the other 3 sides of the square are private properties. And so the entire frontage along Main Street is comprised of a bordering vegetated wetland, and it's 30 feet deep. So an applicant comes in front of the commission and says and behind that is 1.5 acres of pristine flat property per se. And so the applicant comes in front of the commission and says, I have to basically fill in the entire bordering vegetated wetland or a portion of that in order to get to this pristine property in the back. And historically, the commission has not looked favorably upon that. So it's kind of like a catch-22. I never really agreed with that interpretation of allowing access to a property without a taking. The land has been there for 5,000 million years, and no one's developed the property other than saying, well, this is a nice piece of property in the back, but you can never get to it because you've got to go through the wetland. So in essence, the tax assessor has said, it's a non-buildable lot, and it's always been a non-buildable lot until someone with deep pockets comes in front of the commission and hires lawyers and tries to fight that argument. So it puts us in a very difficult position in that case. How would you proceed on going forward with that?
So the first question is, was that property ever combined with one of the other abutting properties? That's the first thing that the applicant has to prove, that it was never combined. Second, I know you used bordering vegetated wetlands as an example, but under the act, they have the right to fill in 5,000 square feet as long as they can replicate, bordering vegetated wetlands. And then again, if they need more than 5,000, then they can come in under the limited project. Now that is all under the state act. And then, your bylaws, you have to decide if you are creating a situation where it's going to be a taking of the property. Now, there is case law that says that a taking of the property means that you are prohibiting all use of the property. So is that property valuable to abutters? Is it valuable to an abutter for parking? Is it a value, value to an abutter, for a garden? I don't know, but those are the things that you have to determine to avoid a regulatory taking. So most of the regulatory taking, so it's the Davis case, the Chatham case, where the court held that the property could be used for, it would be desirable for an abutter for parking and picnicking.
What about do wildlife get value? I mean, what if this billiard table is not such a billiard table? It's a wild area that has been used by deer and all the other critters that run around Cohasset.
Yeah, only if the wildlife is endangered wildlife. If not, it has to be wildlife habitat, which is extremely difficult to show that that it's going to be severely impacted.
And the burden of proof then would be on us. We can't presume that it is wildlife habitat.
You cannot, no.
Okay.
Yep.
Yeah. Okay, thank you.
It appears in the wetlands manual that wildlife habitat has a much looser definition than you're giving it right now. It seems to me that you can go through and prove that there's skunks and squirrels and other things going through there, that there have been foxes dens in the past, and that type of thing would meet the definition of a wildlife habitat. What you're talking about is something that goes way beyond what we have. I think what I would presume from what we have in the words of our wetland regulations, because it's almost impossible to do what you want to do.
So the protection of wildlife habitat, if you have 1.5 acres of pristine upland and you're going to build a driveway and a house, there's not a chance that a court would find that that is impacting wildlife habitat that you described, meaning skunks and deer. It's 1.5 acres. So you're putting up a house and a driveway. So you can't show that is going to, that's going to have an impact on wildlife habitat that cannot be protected. So, for example, I've gone to court over a condition that the applicant wanted the entire property fenced, and the commission said no, because you are going to impede wildlife migratory patterns, and we ended up settling for a fence with a very large gap at the bottom, but the applicant still wasn't happy. He wanted a stockade fence to keep his dogs in. Well, it was shown that area was used by habitat to move from one wooded area to another wooded area, and so that's where you get into these situations. But if you're putting up a house with a driveway, I don't know how you can prove to a court that that's going to impact wetland habitat, or wildlife habitat, to the point where you're going to deny the project. I think it's going to be very hard to show.
I can understand what you're saying. I think it's probably from an economic viewpoint and a business viewpoint, maybe not a wildlife, maybe not an environmental viewpoint, a reasonable thing that you're talking about. But I find the law that we have written in front of us that doesn't even lead us in that direction to some sort of fuzzy cost benefit analysis.
No, I'm not using a cost benefit analysis. What I'm saying is you have 1.5 acres of property of upland, and you're putting up a house and a driveway. So what I'm saying is you have these large properties. I don't know how you're going to show that wildlife is being impacted. If you have a 5,000 square foot lot, and it's surrounded by woodland, I guess maybe we could say that putting up a house and a driveway is going to somehow cut off the wildlife habitat. I don't know, it's
I think the bottom line for us is that case law is, we'd be trying to swim against case law, and we'd probably lose.
Yes, definitely.
Okay,
Yep.
so that,
Yeah.
so for all of the wildlife we might want to save,
Yeah.
it would be futile to try this. I think there's another sort of slippery side to this that I'm trying to wrap my head around. The comment that you made that at some point in the past, you didn't define how far in the past, a property was bigger or wasn't connected in some way. So in other words, let's before some of these lots were, a lot of our lots were formed in the 50s from much larger estates. And so if at one time a lot had been part of a larger parcel that would have had access, but it's lost it during that subdivision sort of activity, how do you deal with that? I mean, is there some statutory or maybe something that the court uses as some bar for how far back you have to go? Because, you know, if you go back far enough in Cohasset history, you know, there's a lot of lots here that were just wood lots that were 50 feet wide and would run for hundreds and hundreds of feet, and we still see that on our parcel maps. So it can be really complicated here.
So I'd have to look at 10.53 as to how long they go back. I want to say, and don't hold me to it, I want to say it's 20 years that they go back, that you can look. And they're supposed to provide you with that title information to show that they couldn't have gotten in there.
So the reason I wanted to bring this just boilerplate example out is because it's a fairly common situation in the town of Cohasset, given the fact that we just don't have these nice flat wooded lots with no wetlands on it anymore. So inevitably, these somewhat may have been non-buildable lots in the past that are going to be in front of us. But I think it's more to obviously clearly to get away from the wildlife habitat issue and focus in more, in my view, and Amy, tell me if you disagree, on the impact to the bordering vegetated wetland as a result of the construction, whether it be an asphalt driveway, stormwater runoff, the direction of flow into the wetland itself. So to look at and assess the environmental impact to the wetland itself as a result of the alteration of the project.
That is correct. Yes. So moving on to, going into emergencies a little bit more. If we go to the next slide. Emergencies, again, it has to be necessary, to protect the wetland values for the health and safety of the public. Again, the wetland values that we're usually looking at here are erosion. They can, it has to be the federal government, Commonwealth political subdivision. They need advance notice. And the work, it's only to abate the emergency again. And then again, this, it must conform with performance standards, adopted by the commission. I don't see that you have any emergency performance standards. And then under your bylaw, they have to file a notice of intent within 21 days after the emergency project. Under the act, it's 30 days, but your bylaw is more stringent. So we can move on. And so with your bylaw specifically allows you to enact rules and regulations. Chapter 40, section 8C, again, also allows you to enact rules and regulations. 48C provides that rules and regulations can only be implemented after public notice and a public hearing. It has to be advertised in the newspaper, posted at the town clerk. The proposed rules and regulations have to be available for viewing prior to the public hearing. It can contain obviously rules, regulations, performance standards. It could also contain design specification, policy guidelines. The rules and regulations have to accomplish the purposes of the bylaw, and they have to be consistent with the bylaw. So your bylaw provides that you have jurisdiction within 25 feet out from an isolated land subject to flooding. Your bylaw cannot provide that your jurisdiction is extended to 100 feet out. It has to be consistent with your bylaw. So the way that I always think about it is it's an upside down triangle. It's the statute first, then the bylaw, then the rules and regulations. So it goes from, from more powerful, it goes the statute, the bylaw, and then the rules and regulations. So you can amend your rules and regulations at any time. It's the same as implementing rules and regulations. So again, there's public hearing, public notice, things like that. And then you can also adopt a fee schedule. And again, a fee schedule is public notice and a public hearing. And its fee schedules are subject to final approval by the select board, as they are the CEO of the town. They're the ones that control all of these things. So the fees fall within their approval. Other than that, they do not have to approve your rules and regulations, provided that they are enacted in accordance with the statute. So the next slide is so the quorums. So under the wetland, DEP has made it a little bit confusing for quorums, because under the Wetland Protection Act regulations, it's a majority of members then in office. And it states that a commission action requires a vote by more than half of the members present at a meeting of at least a quorum. So in that situation, if you only had 5 members that were appointed, your quorum would be 3, and you only need 2 out of the 3. So if for example, 3 people show up, you have a quorum, you only need 2 out of 3 to act. But that's not the case under your bylaw. Under your bylaw, it's a majority of members then in office, and it's more than half of the members present at a meeting of at least a quorum. So it differs from the general law, which it's a majority of 7 members. Your Conservation Commission is 7 members. So regardless of how many members are in office, your quorum will always be 4 members. So that's the one difference. So I always advise that you go with 4 always. So moving on. So your procedures, for filing a notice of intent, upon receiving an application or a notice of intent, you guys have to schedule a public hearing within 21 days. Your bylaw says that the hearing will be held within 30 days. Actually, that's not right. I actually went back and looked, and your bylaw also says 21 days. So that is wrong. I'm sorry. At first, I thought it was 30 days, and then I went back, and it is 21 days, but I didn't make the change on this. I apologize. Your hearing has to be advertised in a local newspaper. It's at the expense of the applicant, and all abutters within 300 feet, or within 100 feet of the property line on which the project is to be carried out, whichever is greater. And they have to be noticed by certified mail, which again is the expense of the applicant. So at the public hearing, the commission, you are required under the state regulations, you're required to review proof of abutter notification. That can be done ahead of time. It doesn't have to be done at the public hearing. It definitely can be done ahead of time, which I think saves a lot of time. So if you need more information, you can continue the hearing on your own as the Conservation Commission, but it can only be continued to 21 days without permission of the applicant. So if you need more information and the applicant says, I'm not going to grant you a continuance, you can continue it for 21 days, but that's it. And if not, then, you have to, you basically have to close it. And if you close it, you are going to want to, close it. And if the information is not provided, you need to deny it based on lack of information. And that's, I think, if we go to the next slide.
Amy, I have a quick question. So
Sure.
if, in most cases, we would have, a representative presenting on behalf of the applicant. So if we decide, during the meeting that everyone wants to continue and the representative agrees, does that count on behalf of the applicant, or do we also need
Yes,
to
it
get
does.
there? Okay, cool.
It does. The representative will, it's assumed that they have the power to do that on
Great.
behalf of the applicant.
Okay.
So yes. So you have to you have to issue the order of conditions within 21 days of the public hearing closing. And that is, and again, your bylaws do not state 30 days. I didn't change it here either. I'm sorry. But it's 21 days in your bylaw also. If you do not issue the order of conditions within 21 days and you do not have a written extension from the applicant, you lose jurisdiction and it goes directly to DEP. You lose your 100-foot buffer zone, you lose all of that. And so it's very, very important to issue orders on time. Your order of conditions can be a combination of the WPA form, findings and conditions. So you can have the form and then you add, obviously you guys do this, you can add your own conditions. I highly suggest you add findings. Findings are very important when you're issuing a denial, because, you want to state your effort to maintain, obtain information, findings that are specific to a certain resource area. So for example, if you have a coastal bank, you want to put, findings that the bank will not be replenished and therefore we can't do this project. It needs to be more than just a recitation of the performance standards. It has to be project specific. So I suggest you go through the performance standards and make sure the project meets the standards. If it doesn't, state why. The order of conditions, obviously, you all know, has to be recorded at the registry prior to the start of work. You have to, they have to require proof of recording, and the order of condition is valid for 3 years unless it's extended. Extensions can be granted for up to 3 years, but the request for an extension has to be made 30 days prior to it expiring. So they can't come in with 1 day left and say, "Oh, I need an extension." So, and that's because you guys have to hold a hearing, or you guys have to hold a meeting. You don't have to you don't have to do a hearing, but it has to be at a public meeting that you vote on the extension, and that's why. So we can go to the next slide. Requests for determination of applicability, those can be filed by anyone. A neighbor, concerned citizen, anybody can file an RDA. Once you receive it, you have to schedule the public hearing within 21 days, has to be advertised in the local newspaper 5 days prior to the meeting. The commission has 21 days to make a determination. And you review the work to make a determination whether or not it falls under the jurisdiction of the act or the bylaw. As you know, there's a negative determination where work can begin without further notice of intent. With a negative determination, work can begin after the 10-day appeal period, and work can continue even if there's an appeal. So the work can continue at the owner's risk if it's a negative determination under appeal. Obviously a positive determination means they have to come back for an NOI. So work cannot continue until the NOI is heard and the OOC is issued. So we can go to the next one. So for drafting defendable decisions, the first thing is that you want to make sure that the right relief is being sought. You want to make sure that it's advertised properly. You want to make sure that it's been, posted in the proper location. You also want to make sure, and I know that this won't happen until we're, after April sometime, but when we're back in person, if you have a very, very controversial project, you need to make sure that the room that you're having the hearing in has the capacity. So I have been under, it's happened to me at least 4 or 5 times, particularly with, with 40Bs or something, where we are holding a hearing in a hearing room that can hold 60 people. And I literally have to sit there and count. And as soon as the 61st person comes in, we can't hold that hearing anymore because the capacity of the room has been exceeded. So you want to make sure if you have a huge controversial project, schedule it at the high school or auditorium or a very big room. You want to provide all the necessary information and documentation to support a decision. So for example, if you are basing your decision on a scientific document that someone has presented, whether it be the applicant, the agent, you know, whomever it may be, you want to make sure that that document is at least listed in the order of conditions or the denial. You want to make sure that the presentation specifically addresses each and every requirement under the Wetland Protection Act and the bylaw with the regulations. So in other words, you want to make sure the applicant goes through and addresses the performance standards and says, here's how I meet the performance standards. You want to make sure that you don't close the public hearing without stating necessary information that's required. So if you do close the public hearing, but you haven't stated to the applicant what's necessary, you're hard pressed to deny it based on lack of information. You also want to make sure that you take public input. Now, under the open meeting law, you do not, it's a public hearing. And so it's expected that you would take public input. However, under the open meeting law, the meeting is the chairman's meeting, and the chairman can decide whether or not he or she is going to take public comment. Now, for due process considerations, I suggest that the chairperson allow public comment at least once during the public hearing process. So if you have 10 continued hearings, at least one of those hearings, the chair should allow public comment, because it is a public hearing and there are due process considerations to take into account. But under the open meeting law, it is the chairman's meeting. So the chairman decides whether or not to take public comment. The chairperson can also decide whether they want to limit public comment to 2 minutes or 3 minutes per person, things like that. I have some boards that will they'll have people that are in favor speak first, people that are opposed to speak next, things like that. It's all the chairman. It's their meeting again. And so you want to make sure that the open meeting law, conflict of interest, and public record laws are observed prior to issuing any kind of decision. Meaning, if someone asks for a copy of what you're reading, that you need to give it to them. It's a public record. Once it's presented at a meeting, it's a public record. Negotiating conditions to address concerns is a key. It's a key factor. It's always helpful to discuss conditions as you're going along, as you're reviewing the project, and address why a condition is necessary, or maybe it's not necessary or not reasonable. And then you want to keep track of the composition of the quorum that's needed for the action. So I discussed this with Charlotte previously. So some commissions, in each NOI file, at the cover of the file, they keep track of when the hearing, the date of the hearing and which commissioners were there. And then if there's a Mullen certificate, we can keep track of that too. But you want to make sure that every commissioner that ultimately votes has either been there for every hearing or has only missed one hearing with testimony taken, and they have they've filed the Mullen certificate with the town clerk. And again, you want to consider granting extensions of time to avoid the commission making a hasty decision. And the other issue that you have is you also want to make sure that you don't continue a hearing for too long, because then you lose a quorum. So it's a balance. It's a balance that you guys will find. And then any continuance by the applicant should be in writing. There should be a copy of it in the file in writing. So next. So consultants. So consultants come in under chapter 44, section 53G. And so that's different than under the Wetland Protection Act, under your bylaw. The commission, there can be a consultant fee fund where you can require, you can have a peer review a project. You don't need town meeting approval. You don't need select board approval to put money into this fund. This is mostly used for larger or difficult projects. Under the act, the selection of the consultant can be appealed to the select board. Under your regulations, it says that there's no appeal, but the act would 44 GL chapter 44 section 53G would supersede your regulations. So they could appeal. They can appeal the choice of your consultant to the select board. However, under that statute, the only thing that they can argue is that the consultant has a conflict, and that doesn't ever happen. And then you can failure of the applicant to pay the review fee is grounds for denial. And then the DEP has a policy. It was enacted in 2008, and it will uphold the commission's decision to deny based on lack of information and remand it back to the commission if the applicant refuses to allow for peer review or pay for peer review. So it automatically goes back to the commission. So it's kind of a futile position for the applicant to take in that instance. So we can go to the next slide. So for under appeals, if you issue a decision, you issue an order of conditions under the act and the bylaw. Under the act, they have 10 business days to appeal to DEP it's not necessarily an appeal, it's a request for a superseding order of conditions. And that can be appealed by the applicant, an abutter, or an affected individual, or any 10 citizens. And it's a de novo review, meaning the DEP can take the DEP when issuing a request for superseding, or when issuing a superseding order, can take new information. And then if a superseding order is issued, parties then have 10 business days to appeal that to the Office of Appeals and Dispute Resolution, which is the arbitration wing of DEP. The people that can do that is a little bit different. It's the Conservation Commission, the applicant, and then it's an abutter or one resident among a 10 resident group, but they had to have previously participated in the permitting process. And then under the bylaw, the order of conditions would be appealed to Superior Court. It's a certiorari action. It's has to be appealed within 60 days. And it is record review, meaning you cannot supply any new information. It's basically, it's the entire record that the commission had before them. We create a record of proceedings. We file that with the court. And then there's judgments for motions for judgment on the pleadings. And the standard is whether the commission based their decision on substantial evidence or whether the decision was arbitrary and capricious. We can go to the next slide. So for standing, under cert for standing, it's available to people other than the applicant, who they have to establish that they've suffered an injury to a protected legal interest. So, so they have to show that the commission's action resulted in substantial injury or manifest injustice to them, rather than to the public in general. So it's akin to a zoning bylaw standard under a zoning appeal, which is individualized harm. So they have to show that whatever you guys allowed is going to affect them. They're going to have substantial injury and manifest injustice, rather than how it's going to affect the entire area. It has to affect them more. So next. So enforcement. So
Amy, can I just jump in for one
Yep.
moment here, just to reiterate? Because unfortunately, I've been on the receiving end of a couple of arbitrary and capricious filings by an applicant, not only through Concom, but in other business lives. And so the message I want to let everybody know to the commission is that there is also typically, when an applicant files something saying that the commission is arbitrary and capricious, they also ask for any emails, any text messages, any phone records they could. So this is a note for people to be very conscious about not violating open meeting law with emails during the deliberation while the trial is going on, text messages saying things like, I hate this project. I don't like this person. I would never vote in favor. That's just an example. But, things like that just really don't, the courts don't like that at all. And that would be great grounds for saying something actually is you were arbitrary and capricious going in. So we really want to avoid that when we talk and deliberate amongst the projects. I know sometimes I may have to email or call someone and say, hey, you're violating open meeting law, but it really is to protect you and to protect us as we move forward. Because 2, 3, 4 years from now, you're sitting in a courtroom or under discovery and somebody says, did you write this email? And you think, wow, I guess I did. I probably shouldn't have wrote it at the time. So just be very cautious of that when we go through these hot topic projects.
Right, and I actually get to that, Jay, in this. So okay, so we can go there. So for because that comes under public records. So enforcement. So with regard to enforcement, their DEP has an enforcement manual. It's an excellent manual, and basically, the first step is to determine, who you're dealing with and what's going on. Sometimes a simple phone call can resolve the problem. There's, 4 versions we have here, and it's, the violator, they had no idea the activity was not permitted. They knew, but they didn't want to comply because of cost. You just have scofflaws who could care less. And then you have, people that think that the activity is not unlawful. They claim it's not happening, or they challenge the underlying basis for the violation. So next. So obviously with enforcement, you have to conduct an inspection. You have to know what's going on. So the biggest thing is to watch out for trespass claims. You should only enter a private property after obtaining oral or written permission from the owner. You can view the property from a public way, a parking lot, a neighbor's property if the neighbor gives you permission, or with an administrative search warrant. With the administrative search warrant, local police can help you out with that. It's there's forms at the district court. You'd have to go to Quincy District Court. Any application has to be accompanied by an affidavit. Now, I am well aware that the Wetland Protection Act, the Wetland Protection Regulations, and your bylaw allow for you to go on private property. Unfortunately, we're back to that upside down triangle, and now at the very top is the Fourth Amendment. And the Fourth Amendment of the United States is, illegal search and seizure. So it is KP Law's policy to advise commissions or any town official to not go on private property without permission. Written permission is always the best. We can go next. With enforcement, you want to start a log. You want to record, all of your enforcement. So if you speak to somebody, you want to write it down. If you call somebody, you want to make sure that you have a chronology, because and if you could get photographs in this chronology, that's great. Because if the case ends up in court, we're going to be doing a narrative, and the narrative is going to be based on your log. It's going to be based on your timeline, things like that. And I don't know about you guys, but I don't remember what I did yesterday. So you gotta write. I write everything down. It's just it's just the best way to go. Next. And so there's different phases of enforcement. There's telephone. You call the person and say, hey, listen, stop doing that. Sometimes they'll say, I had no idea, whatever. You could do a letter. You can send, just send a letter saying, listen, call the office and we got to discuss this. You can do a violation notice, which is certified mail. It's basically a stop work order, a cease and desist order. But this is more of a preview to the cease and desist order. It's saying, if you don't stop this, we're going to file a cease and desist. You can then file the cease and desist. You can also do the enforcement order, which is a DEP form, section or DEP form 09. And honestly, the more that we have, so if I do have to go into court with enforcement and I have an affidavit from Charlotte that she called these people. She then sent a letter. She then issued a cease and desist, and then she then issued an official enforcement order. I have a lot better standing in front of a judge than if she went straight to enforcement order and they did nothing. So it's always better to go through these steps. And again, these are also laid out in the DEP's enforcement manual, which again is very, very helpful. So you can go to the next. And so, there's a couple.
Just a quick question there, Amy. How do you feel about the show cause hearings thrown in there?
So that usually comes with the violation notice, where the notice requires them to come into the to come in and see the commission and do a show cause. I think they're great. I think that they're perfect. I would use those.
Thank you.
Can you, like, if you're just in the initial phase with like the telephone contact or, just an initial letter, can you mention that we request that you come to a show cause hearing without a stop work order? Or like, do you have to go through like a very specific set of steps or combination, either or?
But I think any show cause, any requirement that they come to a show cause hearing should be in writing.
Okay.
So not by phone. So you can put it in your initial letter, that's fine.
Sure. Okay.
Yep.
And I think we've done a good job with that. And as you mentioned, it lays out a pattern of allowing the applicant or the violator to present themselves to the commission. And either the commission says, okay, this is the required action, or this is significant enough where we're actually going to take an enforcement action. And these are the next steps, etc.
Correct. Yeah. No, I think they're great. So we can go to the next slide. Which is, so there's ways to enforce your bylaw, which one is the non-criminal disposition statute, which is a violation. If there's a violation of the Wetland Protection Act, the penalty can, it can go up to $300 under the statute. I don't recommend you start at 300, sometimes, or just usually sometimes $100 is probably the best way to go. And unfortunately, with the 21D non-criminal disposition fines, we end up in district court, and we never know what is going to happen in district court. We could be before a magistrate, we could be before a judge. It could be a formal hearing in a courtroom. It could be in the hallway with a magistrate. And almost always the fees are cut. They almost never have to pay the full amount of fees. So, there are pros to it, which is that, it can be less expensive. There's a police prosecutor can do it. So you don't need to use town council. The cons are that, there's a lot of second chances allowed. So, but it is one avenue. We can go to the next slide. Under your bylaw, again, it says that you guys have the right to go onto private property. And again, I don't suggest that at all. I don't think you should. But again, you can enforce violations in other ways other than under your bylaw. You can enforce violations other than just the non-criminal disposition, and that is, we can go to court seeking an injunction, things like that. And again, the same thing is, you can also seek enforcement to require somebody to comply with an order of conditions that has already been issued. Next. So now we're moving on to the open meeting law, and this is really just an overview of the open meeting law. The meeting has to be properly posted 48 hours ahead of time, has to be posted with the town clerk on the town website, and you have to have sufficient detail on your agenda so people know what's going on. So you're not going to just put a list of addresses on the agenda. You're going to put, notices of intent to be considered. It's always better to put, say, notice of intent for construction of an in-ground swimming pool, within, 2 feet of a bordering vegetated wetland, something like that. Minutes, the minutes have to be accurate. They have to be timely prepared and approved. You don't have to be verbatim, but you have to have some kind of detail in there. Now, there's new guidance from the AG on the process for approving in a timely manner. It's either within the next 3 meetings or within 30 days, whichever is longer. So that essentially means that for a Conservation Commission, you guys have to approve your minutes at the next meeting. Next. So definitions of a meeting. A meeting includes any deliberation amongst a quorum, and the term meeting does not include an on-site. You are not allowed to deliberate on any on-site inspection. In fact, I advise that applicants don't even converse when you're on site. You know, if you're at a public or private gathering or social event, it's not a quorum, provided you do not deliberate.
Amy, I think you cut out a little.
Oh, sorry.
Amy, I think you cut out for a little bit.
Oh, sorry. So, so with a quorum doesn't mean that there's 4 of you standing around. A quorum means that you have to be deliberating. You have to be discussing commission business. So just don't do it. Don't do it when you're at the onsite. Don't do it when you're in the supermarket or at, you know, a retirement party for somebody. Just, you know, just don't do it. You can participate in business if you're at another meeting. So for example, if you are meeting, if it's you, the commission is meeting with the select board to discuss something. However, you have to notice your meeting. So you can have 2 boards together, but each board has to notice, each board has to open, each board has to close. So we can go on to the next. Deliberation is expressly defined in the open meeting law, and it now includes email. So a quorum of people on email cannot deliberate. And you cannot use a staff member to facilitate communications on matters which need to be discussed at a public meeting. So Charlotte, you cannot send Charlotte your opinions on a NOI, and then she's going to send that opinion out to everybody, because that's the same as you discussing it at a public meeting. Social media is also you know, deliberation. If you are going to start, if there's a Facebook page and you are going to start, you know, 4 of you are going to start discussing something on that, that is deliberation. You know, even an email with your opinion that is then forwarded to the entire commission is a deliberation. And, you know, any kind of chat room or social media, again, is a deliberation. So avoid all of that. The only time you should hit respond all, reply all, we should never hit reply all, actually. Charlotte can send out an email to all of you for scheduling purposes. You should respond back just to Charlotte. Just never hit reply all. It's pretty good advice. The next slide. So for, you know, timing for open meeting law, you have to post the meeting within 48 hours in advance. It excludes Saturdays and Sundays. Saturdays is new. Back in 2016, the open meeting law was revised. It now includes Saturdays. So it excludes Saturdays, Sundays, and legal holidays. You know, unless there's an emergency. Quite frankly, there's very few reasons for a Conservation Commission to have an emergency meeting. Those are usually declared by the Board of Health or the Select Board to declare a state of emergency. So that means for a Monday meeting, notice has to be posted on Thursday, because we can't count Saturday or Sunday. If Monday's a holiday, Tuesday meeting also has to be posted on Thursday. You have to file your agenda or your notice with the town clerk. A meeting cannot be continued from one night to the next unless the first meeting was properly posted. So if you fail to post within 48 hours, you can't post the next day. You still have, that's because your opening meeting did not meet the requirements. So you have to wait and post for 48 hours and then meet. And then the notice required under the open meeting law does not substitute for notice required under any other statute. So again, that means that even though you posted with the town clerk 48 hours ahead of time, that doesn't mean that you posted properly under the Wetland Protection Act. So you have to remember all these different posting requirements. Next. So, practical implications. So if a matter was brought to the attention of the chair after notice has been posted, to the extent feasible, you want to amend the posting. You want to amend the agenda and repost it. May not be possible to update if staff cannot reach the chair. If the chair, if they realize it shortly before the meeting, that could be something that the chair did not anticipate. But there are very limited instances when a public body cannot, can meet without the requisite 48 hours. So poor planning, including looming court deadlines, does not equal an emergency. Natural disasters and public safety issues do qualify as emergencies. The next slide. Conducting meetings, going into executive session, you first convene an open session. You have to state the purpose of your executive session. There's only 9 reasons, I guess, to go into executive session. And, you have to state the subject. So typically we would go into executive session for 2 reasons for a Conservation Commission. One would be to discuss litigation, where an open meeting would hinder our litigation strategy. And second would be to acquire property, whereby an open session would hinder our negotiation ability. So you motion to go into executive session, you have to have a roll call. You have to announce if open session will reconvene after the executive session. Any exhibit or documents used has to be maintained. You would discuss only the matter cited. So just because we enter into executive session to discuss A versus B, we can't then discuss, C versus D. Any vote taken in executive session has to be a roll call. So the next slide. For the minutes, for the content of the minutes, you have to have, they have to be detailed enough so to allow a person not in attendance to determine the essence of the discussion and what documents were used. You have to state the date, time, place, a summary of each topic, which will allow somebody to understand what exactly happened. So if there was a vote, you want to list that there was a vote. Again, you want to reflect the decisions made, actions taken, and then you should include a list of documents that were used. So for example, if an updated plan is presented, you want to list that updated plan was presented. And any document that's discussed by the members should be listed in the minutes. So the next slide. So again, minutes should be created on a timely manner. If they're in draft form, they're a public record. So therefore they have to be made available on any person within 10 days. So that's even for a draft set of minutes. The Attorney General strongly recommends that minutes be approved at the following meeting. And then, the Attorney General has issued a decision stating that 2 months later is too late. So we want to keep on top of the minutes. It's not fun. It's not one of the fun things to do, but it is required. So next. So the chair, when you're recording meetings, the chair has to make a public statement regarding whether, there's audio or video recording if an attendee intends to record. So if an individual wants to record a meeting, they have to inform the chair. The chair has to make the announcement. And, the chair can reasonably regulate recordings, meaning you can't have a TV, crew come in and set up an entire, cameras so nobody else can see. It has to be reasonable. So next. And so now we're getting into, participation. So open meeting law, under the open meeting law, remote participation is allowed. It has to be authorized by the selectmen. It can also be revoked by the selectmen. We're in a little bit of a different situation here because we're in COVID. We're still under the COVID open meeting law exceptions. A quorum always has to be physically present at the meeting location. Again, that's after COVID. That's starting in April. So the person chairing the meeting has to be physically present. So if the chair cannot make the meeting and is going to participate remotely, they cannot chair. They have to hand over the chairmanship to somebody else for that meeting. Everyone has to be audible to each other. All votes are roll call votes if there's somebody participating remotely. Remote members may vote. They're not to be deemed absent. So the chair has to announce the use of remote technology, the members that are using it, and the general reason. Now, under the remote participation state regulations, there has to be a reason why you're participating remotely. It can't be because you just didn't want to go to town hall. So it has to be illness, disability, emergency, military service, geographical distance. So if you're vacationing in Florida and you're going to participate, that's fine. That's geographic distance, but you can't just stay home because you didn't want to go out in the rain. Now, under 940-2910-6B, under COVID Zoom participation, it states that when video technology is in use, the remote participant shall clearly be visible to all persons present in the meeting location. Now, that's been interpreted by the AG's office that board members who have video capability are not supposed to turn off their video during the meetings. So you cannot turn off your video and come back and turn back on. And if that does happen, the minutes should reflect that that person left the meeting. So you want to keep your video on at all times. Next slide.
Amy, this is Jay. We appreciate all of your time. I don't know how long you had intended on going tonight. It's about almost 8:25 now.
Yeah.
And we could probably go on forever. I don't know where you wanted to potentially stop or how long you had intended on going here, or if you wanted to even open up for questions or at some point. So I'm just being cognizant of the timing tonight.
Yes, thank you. So we just have two more brief subjects, which is conflict of interest, which we could, I would sum up conflict of interest in saying that the State Ethics Commission has a phone call, has a number that you can call. Any questions that you have, if you think you're conflicted out of a project, you can call them and get an opinion. You can ask for town council's opinion. However, our opinion can always be overridden by the State Ethics Commission. So I would go with that one first. So we can go to the next slide. And then, any kind of financial interest is a conflict. Any kind of nepotism, things like that are a conflict. But again, I would defer everybody to the State Ethics Commission, to their number. They call back within 24 hours. They're really great. They really are. The next slide. Training, you guys are, you have to be provided with the summary of the conflict of interest law, and you have to sign an acknowledgement of receipt, and you must complete a training program within 30 days of assuming your position, and every 2 years thereafter. So that should be maintained by the town. The next slide. This is the last subject, which is the public records, which you guys really don't have to deal with public records. That's more staff. However, your records, just because you're volunteers, your records are not exempt. So any emails, electronic communications, even if it's sent from a personal email account, is a public record, which also includes text messages. We can go to the next slide. So within timing, this is all stuff that there's a records access officer, which is designated and has to be noted on the website. It's usually the town clerk. They have to respond within 10 business days. There's they can extend that timing by responding with a cost estimate or requesting additional time, things like that. we can go to the next slide. So you know, again, with any public records request, you always want to make sure two things: that you check, that you ask for all documents from your commission, you know, including text messages and emails. And then you do not want to provide any attorney-client privilege communications. So any communications with me, you would want to pull aside, and, you know, most of the times you would send it to us and we would decide whether it's attorney-client or not. And then any information which really would not affect you guys, which is, you know, license numbers, social security numbers, things like that, should be redacted. The next slide. So that's it. So, you know, I do have some time if anybody has any questions. You know, feel free to ask me anything, but if not, we can be done.
I have a question. Going back to the example you used of the pyramid, and then the you know, if our bylaws are not as stringent as the statutes, for instance, the 25-foot, or not carrying the 200 feet for the you know, for the streams that you mentioned, I mean, what's the point? We should be enforcing the more stringent delineation, isn't that correct?
Correct. So with rivers, you have jurisdiction over 200 feet because it's in the statute.
Okay.
Your jurisdiction is expanded in other areas. Your jurisdiction is expanded into the 100-foot buffer zone for most other resource areas.
So there's an exception to that. I noticed in the bylaws that the 100-year floodplain does not have a buffer. It explicitly says it does not have a buffer.
Mm-hmm.
What does the state say about this?
The state has no buffers. They do not. None of their resource areas, none of their resource area buffer zones are considered resource areas.
So back to that 200-foot stream buffer. We were talking about quite earlier about perennial and ephemeral streams. I think it could be argued that it's a difficult call whether something is ephemeral or perennial in some cases. So let's say you have a clearly defined bank and a stream bed. Is it ephemeral?
No, it's in the regulations under 1058 that determines what's intermittent and what is not. So one of the ways,
the USGS, is that right?
that's one of the ways. Yes, is the USGS. There are other ways to determine whether it's you can do stream stats, things like that. The problem that we always have with regard to perennial, whether it's a perennial or not, is the stream stats don't take into consideration drought conditions.
Yeah.
So one year it might be perennial, but the next year,
yeah,
you know, if you're a year later and you go in, the stream stats could show that it's not because of drought conditions.
Yeah, it just seems to me if there's a clear erosional evidence of regular flow, mm-hmm. that it might be accorded the same level of protection as a stream that maybe only flows at a trickle that it runs mm-hmm. into. And, yeah. and I think it's kind of difficult how we should go about this, because we see this all the time here in town, where there are stream courses that clearly are perennial, but they're too short. Like say connecting to wetlands, they're too short for the USGS to have actually delineated them. Although mm-hmm. you can stand out there in August and see that there's clear flow between one wetland and the next. Mm-hmm. So how do we deal with a situation? Let's say we've got a 100-foot reach between two wetlands, and they are wet all year, but the USGS hasn't linked them.
So because if you only have 100 feet, then no matter what, it's in your jurisdiction. Because
well, that's a bad. Okay, yeah, fair enough. What if it's 200 feet then?
Yeah. So,
Then it still overlaps a bit, but we'll
Yeah.
call it 205 feet, you know?
right. So you'd have to go to 10.58 and you'd have to look into, you'd have to look at how can you determine the difference? And most of it's going to be the stream stats
Okay.
in that instance.
We also have another law about vernal pools. And it says, we start by saying the presumption is something that looks like a vernal pool is a vernal pool. And as I understand the use of the word presumption, if you presume something at the beginning of one of these bylaws or regulations, then the burden of proof is on the applicant.
So in that instance, with regard to your vernal pools, that's in your regulations. It's not in your bylaw.
Yeah, that's right.
So,
well, it is in the bylaws that it has a 100-foot buffer.
yes, it definitely is within 100 feet of a vernal pool, and it doesn't say certified.
Yeah,
and it doesn't say certified vernal pool. So what I would argue in that instance is because there is no definition in your bylaw of vernal pool, that you would go to the definition under the, you would go, I'm sorry, you do have a definition. Let me see. It's,
it does.
so it has to meet the definition. It would have to meet the definition of vernal pool under your bylaw before you can even consider that it's jurisdictional.
That's not quite what it says, does it? I mean, it says that the presumption is it's a vernal pool.
But that's not your bylaw. That's not your bylaw. That's your
regulation.
That's your regulation.
So we wouldn't really be able to enforce that unless
unless it meets the definition of vernal pool, which is holds water for 2 consecutive months between December 31 and June 30th in a given year, and meets the criteria for state certification, whether or not it is so certified. The vernal pool should be capable of providing habitat for obligate and facilitative wetland wildlife species.
Sure. So the state certification process would require that someone literally set up a recorder around one of these, and if they can capture a chorus of wood frogs that is sufficient so that the biologist can't determine how many frogs there are, then that's the obligate species criteria. That and catching some fairy shrimp, and this, of course, this can only happen for about 30 days out of the year, because wood frogs only breed in April. So how do you deal with a situation like this? Somebody comes to us in May. It looks like it's a vernal pool. It's not certified, and can we hold them up for a year? Or do we hold them up for a year? How do we deal with that?
You can't unless they agree to continuances.
So in other words, that's that regulation is powerless.
The definition is what's tying your hands.
Yeah.
Mm-hmm.
So we could change that. That's a regulation, right?
No, it's a definition on your bylaw. You have to go to town meeting.
Oh, wait a minute. The definition of the vernal pool, yes, it is, but the regulation is the one that says it presumes it's a vernal pool, I thought.
Right, but the definition states that it has to meet the criteria for state certification.
Oh, so isn't the first sentence there? I don't have it in front of me, but isn't the first sentence? Doesn't it say that it presumes it's a vernal pool?
The definition of vernal pool in your bylaw says includes any temporary ponding area that holds water for 2 consecutive months.
And if we haven't, so it's kind of like catch-22.
It is.
So how do we deal with vernal pools? That's the bottom line.
So how do you deal with vernal pools? Is you try and get as many certified as you possibly can.
What if it's a there's 2 categories here. There are certified vernal pools.
Yep.
And there are probable, I think if that's not the word they use, potential. They may use the word potential. Vernal.
The definition does not. The definition says meets the criteria for state certification, whether or not it is so certified.
Yeah, what does that mean?
I know, this is what I'm
That's
saying.
What does that mean? Whether or not it's certified.
It means that you're only going to get a vernal pool in March and April. It's tough.
No. That's not quite what I'm getting at. It says whether it's certified or not. I mean,
Right.
So, but you're saying it has to be certified for us to treat it as a resource.
No, it has to meet the criteria for state certification, whether it's certified or not.
So who is obliged to establish that it meets the criteria?
I think that
Us or the applicant?
well, I
Well,
think the
could
applicant.
that be done through a third-party independent
yeah,
review
or-
from
yeah,
a wetland delineation?
The state allows amateurs to do this. In fact,
Yes.
they encourage homeowners to do this.
Mhm. Yep.
But we would probably want to see a wildlife biologist establish this. So
Yeah, or a wetland scientist can
Yeah.
certify vernal pools. Yeah.
a wetland
Yep.
scientist. So again, the hypothetical is an applicant comes to us in July. It looks like it meets all the criteria, but it's not certified.
That's fine, as long as it meets the criteria for state certification, whether or not it's so certified. But you have to show that it meets the criteria.
So who has to show that it meets the criteria?
Well, if the applicant is saying no and you're saying yes, I think you have to meet the state certification.
Okay, so then we wouldn't be able to do that for another 10 months. So how do you deal with that?
You don't. You can't. I mean, the only time that you're going to have a vernal pool as a resource area is if it's other than, I would say, March, April, and maybe the first 2 weeks of May, maybe.
Well,
it needs to be certified.
well, I was talking to the biologist who's in charge of the program, and I believe that it needs to hold water for 60 days, somewhere between January 1st and July 1st.
Yep.
That's the window.
I think it's actually, it's December 31st to June 30th. Yeah.
Yeah.
But so
it's the other part that's tough, right? Because you can probably find he said you can find fairy shrimp there from almost from the moment the ice is out, but it's the frogs that are the tough part, because they only breed for 3 or 4 weeks sometimes. As soon as the water temperature hits 40 degrees, they're
but
out
you don't
there
need
trying to-
both. You only need one. You don't need both.
One what?
You don't need both. You don't need the frogs and the fairy shrimp. Fairy shrimp will do it.
No, that's not what he said. He said you got.
No, I'm pretty sure it will.
I was talking to the guy
Years ago,
decisions about what.
years ago, we certified a vernal pool that was based on it was at an abandoned subdivision, and it was the result of a truck tire mark, and it literally created a vernal pool, and we did it with fairy shrimp. So maybe it's changed. I'm not an expert on that.
Yeah,
I've only done it as a commissioner.
He said we would need both. We would need to capture some fairy shrimp, and the obligate species in this case is a wood frog. And we need a lot of wood frogs. He said, don't send me a recording with 3 where I can tell there's only 3 or 4 of them. He said, we need to hear a chorus so we cannot distinguish how many frogs are present. So that's his threshold. He's the one that makes the decisions about it, actually.
I would go with him. I would go with what he says, not what I say.
Oh yeah, but it still doesn't solve our problem, I guess. Other than, I mean, maybe you already have. If we can't prove it, then we can't enforce it.
It's difficult.
Yeah.
Yeah.
What about other types of wetlands, like just vegetated deciduous wetlands that are not that the delineation doesn't meet reality or whatnot, and say it's not delineated at all, and work were to take place, would the property owner be responsible for like recognizing that even though it's not delineated?
Yeah, I mean, if an applicant comes in and claims that there's an area that is clearly vegetated wetland and he or she is claiming that it's not, that's when we get a peer review to go out there and you know, confirm the wetland line. And that's done by vegetation, that can be done by soils. You know, there's
Sure.
many different, there's the DEP, you know, wetland maps, which obviously you can't rely on 100%, but they're very good guidance. So there's a lot of ways. There's a lot of ways to delineate wetlands.
I think my question was more if work already took, you know, could you basically hold someone, you know, responsible for altering wetlands if it was not delineated?
That's when you need to look at hydrate soils. Yeah, you would go in and look at the soils. So but
Okay.
that's mostly how, you know, when there's unpermitted work, usually the vegetation is removed, and so that's when you go to soils and you look for hydric soils, and also that's where DEP maps come in very handy. You also have previous delineations. You have delineations from abutting properties, things like that. There's a lot of ways to figure out the correct delineation of a wetland. A wetland doesn't just end at a property line, and even though you know, wetland scientists and homeowners seem to think it does, it doesn't. So there's other ways to figure it all out.
Amy, when it comes to wetland delineations on a site plan, obviously we want to see them, you know, done very recently, preferably the year that they're applying. And then of course delineations expire after 3 years. So I guess when we see, you know, outdated delineations on a plan, you know, I think we as a commission, you know, we can request that they have to be redone, obviously. But then I guess when it comes to, you know, looking at, you know, on a site plan, let's say you see the delineations done by this person during this date. Are we able to ask for, you know, any information about how the delineations were done and what kind of
Yes.
variables were used to determine? Okay, so we don't just have to like take their word
No.
for it because it's on a stamp site plan.
No, you don't. No, you don't. No, you can, you know, you can also, you can inquire about how they came up to when the delineation was taken, how they did it, you know, there all kinds of information. Yeah, you can.
Is that something I don't think it's necessarily required for an NOI, but we can obviously as a commission, if we, you know, want more information about it, we can request it.
Yep. Yeah, if it's questionable, yeah,
Mhm.
you have the right
Okay.
to do that. Yep.
So there's all these natural features that we're trying to definitively outline, find their boundaries. Coastal bank's another good example where it's defined as the first incidence of a 15-degree slope, but after let's see, past the high water mark or the zone of flooding, you know, the floodplain. That can be quite a ways away in a flat area. I mean, that could be a 1/4 mile inland.
Mm-hmm. Yes. So DEP has a policy for delineating coastal banks.
Yeah.
And that policy has been upheld in both at the OADR and in state courts. So that's the only way to determine. That's the only way really to delineate a coastal bank.
Is that 15-degree slope?
I'd have to look at the policy. I don't remember offhand if it is 15 degrees or not. I know that it has to be preceded by a coastal beach. You know, there's all kinds of things in the policy.
So a salt marsh wouldn't. If you, so that raises another question. I saw that it's the regulation is really written towards preserving coastal beaches and dunes, it seems to me. So when you don't have a beach per se, you have a salt marsh. Is there actually then a coastal bank that is involved?
Not always, but salt marsh is more regulated than coastal bank, coastal beach, and coastal dune. Salt marsh is probably the highest regulated resource area in the.
Yeah, I realize that, but if you, but inland from that, there might be a coastal bank or not.
There could be. There doesn't always have to be. It would all depend. That would depend on the slope, but
yeah, again,
I would find it unusual.
You could go 100 yards inland from the edge of the or more inland from a salt marsh before you found a 15-degree slope. You might
That
go
wouldn't be a
mile.
coastal bank. It wouldn't be a coastal bank.
Okay, so
No. Yeah, so,
I guess we need some clarification.
mhm.
Maybe not from you, but at least find something in DEP guidance for how you deal with a situation like that.
Amy, I think and these are all really great questions and great examples. Is there, would you be able to provide perhaps some decisions or some denial order of conditions that have been, that have stood with the courts, factual and have good sound basis behind them from other towns that you might be able to share with the commission that
Yeah,
would
so-
kind of back up some of this? And
Yeah,
because
so
I think that all of this is great information, but actually seeing a town's response to this that has been stood with the court would be very helpful.
Yeah, so a coastal bank it can never be 100 feet away from, it has to be adjacent to a resource area. So a coastal bank has to be, it's either a coastal beach or land subject to stormwater flowage. There has to be a resource area that it's adjacent to. So you're never going to have a salt marsh and then 100 feet of something else and then a coastal bank.
So it literally has to adjoin. It has to
Yes.
be on the edge of the resource. It can't be separated by.
Coastal banks are defined as the seaward face of any elevated landform other than a coastal dune, which lies at the landward edge of a coastal beach, land subject to tidal action, or other wetland. So it has to be adjacent to another wetland.
Oh, okay.
So it's not just the elevation. It's not just the slope.
The slope. Okay, great. That clarifies that.
Yep.
That's
And
that's easier than vernal pools anyway.
That's policy 92-1, DEP policy 92-1. And then there's also figures that show you. There's 7 figures attached to that policy, so
Great.
those help.
Yeah.
Amy, this has been extremely helpful. I know that we said 8:30 this evening and we're
Yes.
about 20 minutes past that. So I want to be cognizant of your time and energy here. I think that if you're amenable to it, we should probably wrap this up, but also try and do this again, quarterly or in a couple months with a dedicated subject, whether it be the resource area or enforcement or whatever the issue may be. And then really hone in on that. And I think that would be a benefit to the commission as well.
Right. That's fine. That
Okay.
sounds great.
All right. Well, it is now 8:48. And since this is a public hearing, do I have a motion to adjourn?
So moved.
Motion to adjourn and a second. Let's do a quick roll call vote here. In favor of closing the meeting, Tom Bell,
Tom Bell,
Eric Eisenhower,
Eric Eisner, aye.
Kathy Berrigan,
Kathy Berrigan, aye.
Chris McFarland,
Chris McFarland, aye.
Jay Pimpare, aye. That vote passes. Have a great evening, everybody. Thank you, Amy.
Thanks,
and we'll
everyone.
See you in a couple weeks.
Thanks, Amy.
Thank
Thanks,
you.
everyone.
Thanks, Amy.
I'll see you soon. Okay, bye.